नमस्ते फ्रेंड, आप सभी का एक बार फिर से वेलकम। और बात करते हैं बैंक पेंशन अपडेशन पे। श्री जे.एन. शुक्ला जी का एक राइटअप जो उन्होंने बड़े ही समझदारी के साथ उसको लिखा हुआ है। इम्पॉर्टेंट नोट: एवरी रिवोल्यूशन बिगिंस नॉट विथ फायर बट विथ क्विट रियलाइजेशन ऑफ इनजस्टिस। एग्रेसिव होने से नहीं कोई काम होता है, शांतिपूर्वक आगे बढ़े। बी वेयर ऑफ द मैलिशियस प्रोपेगेंडा, इस बारे में उन्होंने लिखित किया है। हालांकि इन दिनों जब से 20 मार्च की घटना MC सिंगला केस में कोर्ट में हुआ, उसके बारे में क्लेरिफिकेशन, सफाई, और अल्टीमेटली ये अभी पता नहीं है कि 27 मार्च या 4 अप्रैल कब इसकी सुनवाई होगी। लेकिन चारों तरफ से, हमारे पेंशन एक्टिविस्ट साथियों की तरफ से, AIBPRC की तरफ से, सेवाराम जी की तरफ से, सबके सफाइयाँ आ रही हैं। लेकिन फैक्चुअल पोजीशन ये है कि उस दिन अभी उसमें कुछ आगे बात नहीं बनी है, और कब बनेगी 27 मार्च को भी उम्मीद कम है, 4 अप्रैल को क्या होगा अभी कुछ नहीं कह सकते। ए सेक्शन ऑफ द पेंशनर says that there is no mandate of periodic pension updation like the one in government and RRB pension regulations. Those who say it should dig out the explicit clause of RBI pension regulations 1990 are central pension rules and place before working and retired bankmen. Just say is not educated to believe it is necessary to tell people that the RBI pension regulation is the same as per the BEPR 1995. There is no explicit provision either in RBI pension scheme or CCSR. Under system, when the Government of India constitute CPC, Central Pay Commission, it refers among other things to examine pay, allowances, service conditions and the pension revision issues for central government employees. Wage revision in banks are done on the basis of COD given by unions, neither in government approval of CPC recommendations nor in wage revision settlement of the banks. There is any explicit provision of the next pay revision, since the tenure of the settlements is stipulated. Next settlement is implied, and that's for unions submitted new charter of demands. It is not written anywhere in the pension regulation that it will remain static or dormant, unchanged, or there will be no updation, improvement, etc. because such things are bound to happen since BAPR is linked with CCSR 1972, Commutation of Pension Rules 1981, and RBI Pension Regulation 1990. In such a situation, there is no strength in the argument of those who say no explicit clause in the BAPR 1995 as excuse of no pension updation. The RBI revised pension in 2003 under its regulation similar to BAPR 1995. There was one flaw in the RBI revision that it did not take prior approval of government as stipulated in the regulations and was mandatory. As far as the financial burden is quoted as a reason for non-revising pension, it is an issue to be attended to and addressed by banks. The pensioners have nothing to do with it. It is the contractual obligation of banks to maintain the adequacy of pension funds. Banks were in heavy losses when the 11th wage revision was done at 15% wage hike. 15% wage hike was neither mandatory nor any contractual obligation at all. It was negotiable. It was negotiated and agreed to. But pension updation has been a settled matter and a contractual obligation, but banks have not been doing it. If someone says that the pension updation is a matter of cost implication worth rupees 95,000 crore, we can say fallacy has no limit. If so, it implies that this much money is snatched, stolen from bankmen, since they have been rightful recipient of the pension updation with wage revisions, which banks have not given to pensioner in the name of financial crunch to which pensioner have no concern at all. It has to be understood here that such a situation has happened because the pension revision has not been done from the 6th to 12th wage revisions, and it is a matter of 100 takas that it is the contractual obligation of banks which are owned by the government of India, and banks cannot detract and deflect from their contractual obligations having sovereign status. It is noteworthy that the pension scheme has been a given and take deal between the bank's management and the bankmen. The conditions of the deal has been fulfilled by the bankmen by surrendering their right to the contributory provident fund of banks in lieu of pension. Banks cannot retract from the implementing pension agreement and refuse pension revision along with pay revision, indicates linked DA and other reforms that occurs in central civil servant rules and RBI pension schemes. We believe that the current status of the pension corpus is relative to the liabilities of the existing pension scheme. If there is a change in the pension eligibility rule, that is, if pension revision occurs, then banks will have to cough up additional money in pension fund for this. The big relief to banks would be that pension revision on RBI line will be from prospective date as precedents if mutually settled out of court by the banks. Banks will not be loaded with arrears. One more thing, the financial burden which is being shown in the event of the pension revision has no basis. It is an attempt to present a horrific situation. There is some truth in this. However, this is not a matter of pensioners. As far as pension payment amount from the pension revision is concerned, it was rupees 33,994.45 crore. In the financial year 23-24, the pension revision on the RBI line will increase it is by about 8,500 crores. It is so because it relates to the long span of 6th to 12th wage revision, that is the last 7 agreements. The cost escalation may go around 25% over the existing pension outgo. It would be timely to mention here that in the RBI pension dispute under consideration before the Bombay High Court, the Government of India had filed an affidavit that if the demand for RBI pension revision is accepted, then it will have contingent effect. This will raise the demand for pension revision in other financial sector banks who are presently passing through financial difficulties. The Bombay High Court ordered the RBI pension revision, rejecting this contingent effect hypothesis of the government. The government's contingent effect was in terms of the financial status of the banks and cost in the pension revision, which was rejected by Bombay High Court. Contingent effect matters in terms of a new demand. It has no meaning about the agreed, settled and admitted rights. The RBI pensioner had pension revision right, so the Bombay High Court did not pay attention to the contingent effect contention of the government. In the case of bank pensioner, the contingent effect of pension revision does not matter. Pension revision is legal right. There is no scope for the disorientation in it. Pensioners should not confuse themselves that there is any regulatory difference in the pension of RBI and other banks. The RBI pension regulation 1990 is the same as the bank employees pension regulation in 1993. RBI working unions, considering the pension revision as their responsibility, fought from the table to the court, taking RBI management along. It got permission from the government, and today there is a strong system of pension revision with pay revision. Other banks' unions failed, rather deliberately sidelined pension revision issue and indulged in the anti-pensionary pains tricks. They blacked the golden history of the bank employees movement. in this most nefarious role has been played by Shri J.N. Shukla, नेशनल कन्वीनर। सच्चाई यही है कि बैंक पेंशनर्स को इग्नोर किया गया, उनके राइटफुल राइट को भी जस्टिस नहीं मिला। थैंक यू फ्रेंड्स, नमस्ते।